finish on the loss ground 5 of the appeal. Then there's 2 points which I should have come back to my Lord, Master of the Rolls, on in relation to comments made, and then there are 2 small corrections to our skeleton argument. If I may ask you please to turn to page 66 in the core bundle, paragraphs 95 to 96 of the judgment. The judge held that a further reason for dismissing the application was that, pursuant to paragraph 39 of the petitioner's claim, it's at page 89, but then turn it up, Norman Hay's losses would have been avoided irrespective of establishing liability to Ms. Sage and entitlement to an indemnity under the Global Insurance.
So which paragraph are you reading?
I'm so sorry, 96. So
in the judgment.
67. Yeah. On either scenario, the 2 at 95.1 and 2. Yeah. Plainly, as a matter of fact, if another party had paid some of the settlement sum, then the amount remaining to be paid by Norman Hay, if it volunteered to pay it, would have been correspondingly reduced. But that doesn't change the nature of Norman Hay's voluntary payment, nor does it convert it from being somebody else's loss into Norman Hay's loss. The final point on loss is that in the respondent's skeleton, paragraph 62, on page 150 of the core bundle, it's suggested that the fact that the loss, in the form of the settlement for which the claimant was uninsured, and there it reverts to saying this is all about whether the claimant itself, no other party, had insurance, ultimately manifested in a reduced price received by the claimant upon the sale. So recognising that it manifested in a lesser price for the sale of the shares does not change the fundamental nature of the loss claimed from the defendant. The amount of liability in respect of which the claimant was uninsured, so a suggestion that the claimant is uninsured for legal liability as a result of the defendant's negligence. But then what's pointed to isn't the liability to Ms. Sage in law, but the contractual liability agreed under the settlement agreement. And in our submission, the 2 things are different. What's paid to Ms. Sage under the settlement agreement doesn't mean that, by way of a contractual indemnity which is agreed, doesn't mean that there was any legal liability which would sound under an insurance policy held by the claimant. In relation to a couple of points raised by my Lord the Master of the Rolls, there was a question of what policies were discussed at first instance. May I ask my Lords to turn in the supplemental bundle behind tab 7 to page 222. This is from our skeleton at first instance, which was served on Justice Picken. At 76.3, and I'll show you in a minute at 77, my learned friend Mr. Fraser pointed out to me that we had taken the point at first instance that the IMP's liability to Miss Sage hadn't been alleged or pleaded and wasn't going to be proved. And at 76.3c, we identified, and the responses identified, that the claimant confirmed it was only reciting what had been alleged by Ms. Sage in the US proceedings. Paragraph D is responses 11 to etc., talking about the claimant repeatedly declining to plead that it was liable in law to Ms. Sage. But then E, by responses 19 to 23 and 26, the claimant repeatedly declined to plead that IMP was liable in law to Ms. Sage, or to identify the basis for any such liability in law. F, by responses 23 and 30, the claimant declined to plead that the claimant itself was in turn liable for any liability of IMP to Ms. Sage. And at 77, we submitted in the second sentence, the reasonable inference is that the claimant will not plead that it or IMP were legally liable to Ms. Sage, as it cannot legitimately plead the same and could not evidence and make good on such a pleading. So we're taking the point that there had been no pleading in respect of IMP's liability. As to the nature of the policy, if I could ask your Lordships, please, just to look briefly at page 217, paragraphs 58 and 59. The first example is from the Chubb PA and travel policy that was in the bundle below. The second example, paragraph 59, is from the IMP policy. And it was certainly plain that what we were contending was there would have been some sort of liability policy which would have required the establishment of legal liability. And there was no demur from these being representative of the liability policies. And finally, to complete that, at page 281 of this bundle, which is from the transcript of the hearing, on page 120 of the transcript, at lines 1 and onwards. This is from Mr. Chapman's submissions. He's saying that the judge at trial is likely to conclude that had a liability policy been in place that covered US car hire risks. There are similar exchanges on page 126 of the transcript, lines 10 to 17, and 129 of the transcript, lines 10 to 18. Finally, may I apologise sincerely and correct 2 errors in my skeleton argument. The first is paragraph 20 on page 20 of the core bundle. I've described the escrow amount as £8 million, whereas it should be $8 million US. A rather more significant error has crept in at paragraph 50 on page 28, where we incorrectly state in the 4th line, neither Fraser nor Dunbar was cited and
Paragraph 50.
Sorry, I'm so sorry, my lord. 55.
55. It incorrectly states neither Fraser nor Dunbar was cited.
Yes, and that's quite wrong. They were both cited, and then a New Zealand authority, which may have been dug out by my lord, was then cited and they were distinguished. But I won't go into O&R at this stage, but just to correct that error.
Okay.
My lords, unless there's anything else.
Thank you very much.
Thank you.
Thank you. Yes, Mr. Chapman.
My lords, in short, we say that the judge was correct for the reasons he gave in his judgment. In summary, firstly, as to the legal liability issue, the particulars of claim plead causation in an entirely orthodox manner, consistent with the principles to be derived from the relevant authorities. and there were no grounds upon which that claim fell to be struck out or summarily dismissed. Secondly, the no loss issue is based on a false premise and erroneous analysis. In our submission, and as found by the judge, the claimant clearly suffered the relevant loss, or at the very least has a case with a real prospect of success in that regard. And thirdly, the judge was clearly right to decide that this was a case that was not suitable for summary disposal. And for those reasons, accordingly, in our respectful submission, the appeal falls to be dismissed.
So, I mean, I have three problems with any of that. First of all, what is it your case that they should have put in place a liability policy covering IMP and Norman Hay, or is it your case that they should have put in place a policy of any kind that covered this accident? Secondly, do you accept that you are refusing to plead and to allege that either Norman Hay or IMP was liable to Miss Sage? And if so, why? Is it a term, for example, of the SPA that you can't do that, or what? What's the reason for it? I think those are the two main points. I said there were three. I probably can find another one for you in a minute, Mr. Chairman.
I'm sure.
If not, my Lord Justice may have run out.
Well, my Lord, can I deal with those? And I'll deal with them in summary, and then I'll perhaps take my Lords to some references in the bundles.
Yeah.
As to the type of policy that should have been obtained, the pleaded case is, as we've seen this morning, not limited to a liability policy. It is simply that a policy that would have responded should have been put in place, and then there are various alternative cases as well. And that being the position is in fact reflected in, I think, the passage to which my learned friend directed the court's attention in the judge's judgment at paragraph 84 at page 64 of the core bundle, where one of the contingencies that the judge correctly identified was a matter for trial was the type of cover that would have been obtained. And my Lords, we see that at paragraph 84 of the judgment behind tab 5 of the core bundle at page 64. Where in distinguishing Mr. Justice Butcher's decision, or at least explaining why this was a case different to the position in the case that Mr. Justice Butcher was considering in Dalland, the judge records that the present case involves consideration of a counterfactual, which entails asking what would have been the position had there been a policy of the insurance in place, which there was not. This necessarily involves looking at the loss of chance type aspects, what type of policy would have been obtained, what conditions would that policy have contained, and what was the likely attitude of the putative insurer to being notified by Norman Hay of Miss Sage's claim.
How is that going to work? Because Mr. Shapiro says, with maybe some justification, that he doesn't understand what kind of policy you're talking about if you don't mean a liability policy in the conventionally understood sense, and you've not. You've declined to spell it out in your pleading, so he's going to have to wait till he sees your expert's report saying this kind of policy or that kind of policy would have been available before he knows what the case on this is really about?
Well, look, the first response to that, of course, is that that would not be a justification, and indeed wasn't the justification for trying to strike the claim out. The application to strike the claim out and for summary judgment was based on the no legal liability point.
Yes, I understand that.
It may be the basis for an application for further and better particulars, which of course no application was made on the basis of the answers that were provided. Instead, the strikeout application was made.
Well, he's made about 60 requests already, and you've, on the whole, brushed him off and said, look at the pleadings, and it's all very repetitive. So it's not very far finding out that way.
No, albeit rather than make an application for further answers and further particulars, instead we received the application that was dealt with below. So that's the sort of rider, if you like, to the answer. But the more substantive answer is that the claim is properly pleaded in identifying effectively that one way or another the liabilities either would have been met or would have been avoided. And this is perhaps a slightly unusual claim, albeit pleaded in an orthodox manner, in that, and perhaps this hasn't come through from the passages in the pleading to which my lords have been shown already, that the number of different contingencies on the hypothetical, or perhaps the number of different hypotheticals, is perhaps larger than in the ordinary case, because here we have a pleaded case that one way or another, given the way that Miss Sage brought her claim and given the underlying accident, there would have been cover under a relevant policy of insurance. There are also alternative cases.
So before we get to alternative cases, the answer to my question is that Mr. Shapiro is going to have to wait until he sees your expert's report to find out what are the terms of the policy that should have been put in place.
Well, my lord, perhaps not quite as late as that, and I was going to come on to explain this, in that it's likely that the disclosure is going to bear on this issue, because as we plead, and I'll take my lords to the references, what happened after Mr. Kelsall's unfortunate accident is that the defendant did in fact put in place cover with a view to putting in place cover that would meet the liabilities to Miss Sage. Now, there's an issue on the pleadings as to what was put in place and when. It seems that initially only cover for some of the US subsidiaries in excess of $2 million was placed, but our pleaded case, as I'll come on to show my lords presently, is that eventually, and before the sale obviously to Quaker, cover was put in place, $10 million, on the basis that the cover that was then put in place would have responded to the liabilities. And as we understand it, that was a liability policy, but of course once we've got the defendant's disclosure, which we've not yet received, there's a battle about to be had about that, that will shed light on the steps that the defendant in fact took, in light of the accident, on instructions to go and find cover that would meet the liabilities from the accident, to obtain insurance cover, and what the defendant at least was able to obtain in the market. And that may be confined to that which was actually presented to Norman Hay, or once we've got their disclosure, we may be able to see that there are other policies that were potentially available.
Or
So
would that policy respond without there being liability?
Well, there's not present.
I mean, you can have legal expenses insurance.
My lord, of course. And the point is, and this is why it's to be investigated in light of the disclosure, our case is that Marsh was basically sent away to obtain cover that would have responded in the events that transpired.
Without liability?
Well, the instructions, I don't think, were on that basis. The instructions were, make sure we're now covered against that type of liability.
I mean, what is
forward.
the reason for you not accepting or not alleging that that IMP anyway was liable?
Well, that's my lord's second question. The reason for that is because we've pleaded the cases we have. We say perfectly permissibly, on the basis that a wider inquiry into the hypothetical, or hypotheticals plural, is required, which will include, of course, an examination of the nature of Miss Sage's claim, who it was among her various targets that was likely to have been liable as a matter of Ohio law, and the consequence of that as a result under any putative insurance policy. Remembering that the global policy that was put in place was for Norman Hay and all of its subsidiaries. And it was Norman Hay and its various subsidiaries, together with some John Doe companies, that were sued by Miss Sage.
That's not really an answer to my question, is it?
Well,
I mean, there's a simple point here. There is clear authority that if it can be shown that the policy that you would have put in place would not have responded, then all that's left is loss of a chance. And loss of a chance is not much of a chance if the policy wouldn't have responded. So what I'm asking is, why on earth, I mean, you're in administration, as I understand it. So this claim is being brought by administrators. Why on earth would you not say, well, IMP would have been liable? And then we come to the IMP Norman Hay reflective loss arguments again. But that's Why would you not say that? I mean, why don't you want to say that?
Because on our case, the counterfactual involves a broader inquiry than simply saying, on the counterfactual, IMP was or would have been liable, and IMP would have received cover under a particular policy. The position is that Miss Sage alleged that Norman Hay and or IMP and or some US subsidiaries and or Mr. Kelsall's estate were liable to her. And what we say is that given competence on the part of the defendant broker, we would have been in a position, one way or another, that those liabilities would have met.
But if you're alleging negligence, you have to say what the breach was. And you have to say what a reasonably competent insurance broker, when faced with the problem that you presented them with, would have done for you. Would A, have advised you and then put in place. I mean, this is sort of very basic law. Why don't you do that?
Well, look, we say we do in the passages in the pleading, some of which you've already been taken to. So breach, for example, is dealt with at paragraph 35, and also further particulars are provided at paragraph 36, which we can turn up at page 88 of the core bundle.
But I mean, you are, I mean, can we just be absolutely clear that on instructions before us, you are absolutely determined to maintain the position that it is not alleged on behalf of Norman Hay in this action that IMP was liable to Miss Sage. Is that the position?
Well, my lord, that's not, with respect, quite our position. Our position is that we do not have to plead that.
But with respect, it's a yes or a no. You can say as much as you like about broader inquiry and all the other nuances, but you might be wrong about that. So what I think my lord wants to know, and I certainly want to know, is it your case in this action that IMP was liable to Miss Sage? And that's got to be a yes or a no.
Well, with respect, our case is that one of Norman Hay or IMP would have had the benefit of insurance cover to meet the liabilities. And
Well, I'm going to write that down as a no.
Well, included within that, my lord, is an allegation that one or other of them was or was likely to be liable.
Until I hear you say yes, I'm going to write it down as a no. I haven't heard you say yes.
Well, it is. The answer is yes. It is included within the pleaded case that we bring because it forms part of the well, it is one of the contingencies on the hypothetical that the court at trial will have to consider.
I mean, it's not up to us to cross-examine you, actually, Mr. Chapman. That's not really our job. To say it is included within the pleaded case that we bring is simply not correct. They've asked you hundreds of questions, all of which you've batted away with the indignant response that further and better particulars, which is the reason why further and better particulars should probably be banned, right? But you cannot. I mean, you can say no, and my lord can write down no and put in his judgment or my judgment or my lord's judgment. When pressed, he refused to accept that that was part of their case. But as he says, it is yes or no. If that is the position, then your clients need to understand you may lose this appeal on that ground. I'm not saying you will because we haven't decided anything, but you may. And at the moment, I'm completely foxed by the idea of why you would say that. But there must be a reason.
Mr. Chapman, can I tell you what I think what I think your case is, which I think, if it's what I think it is why you're doing what you're doing, which would at least help me if I can play it back to you. Because I understand your position. What you're saying is, what's critical is what happened after. When you asked Marsh to give you an insurance policy which would have covered what happened, and they gave you something. And part of this, and this is me talking, not you, I understand that.
My lord, yes.
Part of this is they never asked you whether you were in fact liable or not to IMP, but what they did do was give you an insurance policy which you say they said would have covered this situation. And that's why you're not getting involved in that, because as you say, you've banked the idea that they've told you here is a policy which would have covered this situation, and what you're doing is comparing what you were given later with what happened, and that explains, at least if I've understood what you said to me a few minutes ago, that explains the position you're taking. Have I got that right?
My Lord, with respect, that is correct, and that is part of the answer, albeit not the complete answer. The rest of the answer is that, as I was trying to explain ineloquently, is that with respect, on our pleaded case and indeed on the authorities, it's not quite a yes or no answer, because what we're saying is we lost the chance of having cover in place that responded to Miss Sage's claims. And
sorry, you said a word I didn't hear. It's not quite a yes or no answer because?
Because on our case, we lost the chance of having cover in place that would have responded to Miss Sage's claim. Now, that gives rise to either a hypothetical with multiple contingencies or possibly different hypotheticals. So,
no, but I mean, you do understand, don't you, that the hypotheticals are all very interesting. But if the only cover you're complaining about not having would not have responded, you haven't suffered any loss. Except actually you've suffered a gain because you didn't pay the premium for cover that you didn't have. So, that's the point. I mean, the point is the law is not stupid. The reason why Mr. Shapiro is able to point to these cases is because the law is saying, of course you can't sue your broker for not putting in cover that was no use to you in the circumstances in which you're claiming. Of course you can't.
No, of course, my lord.
But if there are uncertainties as to the kind of cover or the kind of circumstances or the facts, I mean, even the famous jeweller's case about Hatton Garden, which I vividly remember because it went on for weeks, was all about, the uncertainties, whether the cover would have been obtained because there was a person who hadn't declared criminal convictions.
Whether Mr. Ratner would have been able to get rid of him.
Well, I don't think was it to do with Mr. Ratner?
I think there was Mr. Ratner in
Was it? I'd completely forgotten that. But anyway, the point I'm making, if there are uncertainties, of course you can sue your broker and you can say, look, I've lost the chance that all these uncertainties would have been resolved in my favour and I'd have got the cover. And in that case, I looked to see if I'd won, as you do when you look at past cases, and I did. I got £230,000, which I remember was a great victory. Now, but it wasn't the 850,000 that had been nicked. But the point I'm making to you is that the law is not stupid. So you need, I think, to go so far as to say, what is the cover that you didn't get me, that you should have got me? Or at least, what is the type of, that there is available? I mean, if the only, of course it's not true, the only type of policy you could ever get is a liability policy, and the liability policy wouldn't respond, then you didn't lose anything. Probably.
But the starting point is that this is, as Lord identifies, a lost opportunity claim. It's a lost opportunity claim, and one's looking at the value of the opportunity lost. Now, if on inquiry at trial, because plainly the lost opportunity claim gives rise to many different issues of fact, including what type of cover was available, would we have paid the premium for it, would the cover have then responded, what would the insurer's attitude have been? It's very much the type of situation, with respect, that Lord Justice Mayles postulated to my learned friend this morning, of that looking at things commercially, most of the time, insurers don't say to their insureds, please treat yourself as a prudent uninsured and deal with a third-party claim and come back to me once a third party has established liability against you. They look at the position more realistically, and they look at the position more realistically, not just in terms of the potential liability to the third party, but who the relevant insured is as well. So, for example, under this type of group policy, if, as was the case, the insurance is arranged for Norman Hay and all of its subsidiaries, and the liabilities was IMPs, then one would expect the insurer to take a commercial, pragmatic view about how it then dealt with the claim. And what our pleaded case is trying to cover are the very many different contingencies to which this claim gives rise because of the nature of the claim brought by Miss Sage and the nature of the insurance programme that was actually put in place, the nature of the insurance programme that might have been put in place on the hypothetical, and the insurance that was in fact put in place thereafter by the defendant broker. And what we've said in answering the requests that have been made of us is we don't need to go beyond what we've presently pleaded, which is a proper plea. Not that plea doesn't include allegations or gives rise to issues and considerations of whether it was IMP that was liable to Miss Sage or Norman Hay that was liable to Miss Sage. Because the position under the various different hypotheticals is one that will have to be considered on a loss of a chance basis, as it was, as my lord will recall, in the jeweller's case. And that's no doubt why, in their skeleton argument, my learned friends took the wrong turn that they did in effectively trying to dismiss the jeweller's case, because that was a case which applied Fraser and applied Dunbar on the basis of, I think, the submissions that my lord made to the learned judge, and assessed all of those contingencies on a loss of a chance basis, and ultimately did so in the round. So the judge in that case looked at what cover might have been available, what the terms might have been, would the insured have responded in order to comply with the terms that were likely to have been imposed by, for example, getting rid of the convicted director, what other steps might have been taken to preserve their cover. And looking at it all in the round, rather than making individual determinations, the judge then said there was a 30% chance of obtaining cover of £850,000, which is why my lord achieved the resounding victory that my lord did of a judgment of 200 and whatever it was £1,000. And that's a perfectly orthodox approach in terms of the application of loss of a chance in an insurance broker's case. It's not necessary for the client as against the broker to plead and prove liability to the third party, or to plead and prove that it was in fact entitled to indemnity under the putative policy that might have been obtained on the hypothetical. What it must do, as my lord successfully did in the jeweller's case, is show that it had a real prospect, a more than fanciful prospect, of obtaining a policy with an insurer.
But the difference between the jeweller's case and this case is that in the jeweller's case there was no discussion about whether, if there had been a policy and no reason to avoid it, it would have responded. I think, remember rightly. But in this case, there is an argument which says that your case is riddled with suggestions that you should have had a liability policy, and you don't allege the liability policy would respond, and they say, well, it won't respond unless there is liability, and you don't say there's liability, so it wouldn't have responded, so you get nothing, even on the loss of a chance. You get nothing on ground one that it would have responded and you'd have been paid 100%, and you get nothing on ground two because it's the same reason.
And that's where there's the difference between the parties on the applicable law, and the judge was right to identify that this is a lost opportunity case, and we have pleaded the lost opportunity in an orthodox manner.
Well, sort of orthodox manner, but even if, let's assume you have, let's not reduce this to a silly pleading point. But you say it's a loss of opportunity case, that's fine, the judge held that it was. But you still have to deal with the suggestion that you're being mercurial, if I may say so, even now, about saying that IMP was liable. It seems, I mean, you know, I mean, obviously there's a big argument about whether he was on his own business or on a leisure or whatever. But I mean, is that an argument that matters to your clients? Why does it matter to you? I mean, I'm just bemused by it. I mean, when judges sort of say, look, you can win this case if you say this, and you turn round to your client, I mean, I was a barrister for a long time, right? You turn around to your client and you say, can we say this? The client normally says, well, do you think we should? And you say, well, seems like we should. And off you go. Now, you may not succeed in making the allegation because he at trial may say, no, you couldn't have won because he was off seeing his mates and he got drunk the night before and he had a Mustang and not a Ford Escort, and therefore definitely you weren't vicariously liable. I mean, I have no idea what the arguments are going to be, but why won't you just say, well, yes, okay, that's part of the allegation?
What would it? I think probably not as clear as I could is that is the gravamen of our case. It is part of the allegation, but what I was trying to explain unsuccessfully is that it is only part. The problem with, if I may say so, the defendant's approach to this case is you have to plead that plead and prove that Norman Hay and only Norman Hay was liable to Miss Sage, and as a result would have been entitled to cover under a liability policy in order to succeed. And that was the basis of the application below. And we said no, we don't have to do that, and we've not done that. What we've pleaded.
Well, he doesn't quite say that, I think, because I think he actually accepts that even if it were shown that IMP was not liable, you could succeed on a loss of the chance, but you'd have to show how somebody might have been liable and how you suffered a loss. So you have to show a chance that you would have succeeded in getting cover.
And that's what we've pleaded. It's the one way or another point.
I mean, my legal expenses insurance is a classic. I mean, if you'd said, well, you should have at least covered me to fight this terrible case in America, which is going to be very expensive. If it was legal expenses insurance, you'd have been covered. I mean, it's not the argument, but it could have been.
No, and what we say is, one way or another, given competence on the part of the defendant, there would have been cover in place that would have responded to the incident, the peril, the Miss Sage's claim. Now, that may have been because Norman Hay had a policy that covered it, and Norman Hay was liable as a matter of Ohio law to Miss Sage, or IMP was an insured under the policy as one of the subsidiaries, and IMP was liable to Miss Sage as a matter of Ohio law, or one of the other American subsidiaries. Whatever the case may be, there should have been in place a policy of insurance that would have responded to Miss Sage's claim. And the way that, frankly, most realistically, on the counterfactual, matters would have played out, it is along the lines of the hypothetical posited by my Lord Justice Mayles this morning, which is
but the position of Norman Hay and IMP is materially different, isn't it? Because it's easy to see, provided only that you're prepared to allege it, that IMP could be liable to Miss Sage because they are Mr. Kessel, is its employer?
Kessel, yes.
And therefore it's an ordinary case of vicarious liability. But there's no possibility that Norman Hay could be liable to Miss Sage unless you are going to plead and prove that Ohio law is different from English law. So the burden would be on you to prove that somebody who is not the employer nevertheless has a vicarious liability. Until you do that, it simply can't arise in this action, can it?
Well, and we do plead that Miss Sage alleged in Ohio.
Yes, but you don't plead anything about Ohio law making that a good plea.
Well, we plead that she pleads as a matter of Ohio law, that the Ohio law doctrine of respondat superior renders Norman Hay liable to her for Mr. Kelsel's negligence.
Well, all the cases make very clear that there's a difference between an allegation and an actual liability, and you've not crossed that bridge in your pleadings.
Well, my Lord, the cases between insured and insurer make it absolutely plain that in order to succeed as a matter of contract under the policy, the insured must establish that it was liable to the third party. And that's absolutely plain. And as my Lord Master of Rolls said this morning, there's no issue between the parties. That's the law in cases concerning a claim by an insured against its insurer. In a case concerning a client against its insurance broker, the claim while putting contract and tort as it is here, as a matter of causation, one is looking at the package of rights that the client has lost as a result of the broker's negligence. And the package of rights would have been the rights.
And why so complicated? Why do we need packages of rights?
Well,
I mean,
because
what the client has lost is the advice of the insurance broker to put in place a particular policy that would have covered him, it, and the policy, and therefore the fruits of that policy.
my lord, yes, but that counterfactual carries with it a consideration of what was likely to have happened had such a policy been put in place. Now, in most cases, reputable insurers do not require their insureds to act as prudent insureds and to prove the various liabilities. Instead, as per the example we were discussing this morning, or rather the Lord Justice Miles was discussing with a learned friend, insurers look rather more commercially and pragmatically at the matter and say, well, look, this claim has come in from Miss Sage. Miss Sage is alleging what she alleges, which includes Norman Hay is liable under the Ohio doctrine of respondent superior. Alternatively, or perhaps further alternatively, IMP is liable as Mr. Kelsall's employer and also under the respondent superior doctrine. I could look at this and say, well, look, the position's terribly unclear as a matter of Ohio law. I'm not going to cover this until the position is determined by an Ohio judge and jury. Or more realistically, I could take the view that under this policy, one way or another, and that's why we plead it as one way or another there would have been cover, one way or another, I'm going to be on the hook here for paying out in respect of Miss Sage's claim, and no doubt relying on similar advice to that which was in fact obtained by Ohio lawyers or from Ohio lawyers, the insurer would have taken a view that the claim from Miss Sage ought to be settled on terms as it was. And in those circumstances, Norman Hay would not have faced the liabilities that it did. Now, that's the way we put the case in the pleading. One way or another, that is what the outcome would have been on the counterfactual. And we don't need to go beyond that as a matter of pleading, and the judge was right so to find. Now, one of the reasons we don't need to go beyond that is, as I've now just sought to explain, is that within that case, the one way or another case, are those various different contingencies. One of which is that Norman Hay is liable as a matter of Ohio law to Miss Sage. Another is that IMP is liable as a matter of Ohio law to Miss Sage. So it's that those issues are within the pleaded case. And the reason why we've taken the position that we have is not to be difficult. It is not because we don't want to face up to the issues the Ohio claim gives rise to. It's that being realistic and pragmatic about it, when looking at the counterfactual on a loss of a chance basis, one doesn't need to go as far as having to plead and prove either one of those alternatives, because we as the putative insured do not have to be confined and should not be confined to having to pick one of those alternatives. Because our case is, on the counterfactual, one way or another, we would not have been left with the liability.
In practice?
In practice. So, my lords, we don't shy away from acknowledging that our pleaded case obviously gives rise to issues of whether...
And you say you would not have been left with that liability whether or not one or both of Norman Hay and IMP was liable, in fact, to Miss Sage in law. So.
Yes, because the insurer, looking at the position pragmatically in the round, would have taken a view, as being uninsured, Norman Hay had to take a view, about what the position was likely to be in.
I mean, that sort of slightly puts me in mind of the obligation on insurers, or lack of an obligation, to take over a defence. I mean, normally, pragmatically, they do. They don't always have an obligation to do that.
No.
They cannot just simply turn around and say, you act as prudent uninsured.
Yes, do your worst.
We'll tell you if we're going to pay later.
Yes. More realistically, the insurer looks at the position and says, well, look, we're going to end up paying this. It's in our interest to take over the defence, and so we will.
Yeah, make sure it's properly defended.
Yes. And
get a better settlement.
And that's the opportunity that's been lost. It's having the insurer on the scene and on the hook. And that's the case that's been pleaded. It's a perfectly proper plea. It's not a demurrable plea. It's not one that falls to be struck out.
Well, that's quite what we're deciding, really. Whether it's a perfectly proper plea.
Well, I should have prefaced that by saying in my submission, it's a perfectly proper plea, and once there's been disclosure and evidence, including no doubt, as my lords identified, likely expert evidence, we will either succeed or that or not.
And you say that's why, paragraph 41, the judge didn't mention the first bit of the Fraser case because it wasn't relevant. It was only the second bit, in the alternative, if I had not decided that, there is a possible loss of a chance case.
My lord, yes, and there's a further reason which I'll come to, which is the correct analysis of the principles. But there may well be a narrowing of the case between now and trial, depending on, as I've indicated, the disclosure that's obtained in respect of the efforts to obtain other cover. There may well be a narrowing of the case depending on the expert evidence. But whether or not this is a proper case to go forward, we say is clear, as the judge found. This is a perfectly permissible plea.
What he says is, there's a very simple legal question here, and that is whether or not liability is essential, that there was liability is essential to liability of the broker to the client. And here you haven't even alleged that, and therefore you fail. And we should decide that. It doesn't matter what the facts are. I mean, if he were right, he's right.
To which the answer is he's not right as a matter of law, which I'll come to. The pleading in any event covers, as I sought to explain, the legal liability issues. What it doesn't do is from those various different options say it's this one, because we're not required as a matter of loss of a chance to pick one and only one, or even two of the various options.
I've got that point.
The case you're making, i.e. that the insurer would be expected to adopt a pragmatic and commercial stance, the judge addressed that in paragraph 93 of the judgment and said that it may be that such a case should be set out more clearly in the particulars of claim. And then in his order, at page 44, he said that if you were going to amend, you had to serve a draft by 28th of May 2024. Did you ever do that?
No, we didn't. Because the judge found that the existing plea was a permissible one, and certainly one that did not fall to be struck out. And so we did not avail ourselves of the opportunity to amend at that stage. That's not to say...
I obviously expected you to spell out such a case if you were going to make one. Otherwise, what's the point of paragraph 2 of his order?
Well, he actually said it was up to us. In fact, at page 310, Mr. Cameron reminds me of the supplemental bundle in the transcript. The judge made it expressly clear that he was leaving it up to us and not expressing a view one way or another. So the supplemental bundle, tab 11, page 310 at the bottom of the page, the judge said, and to be clear, I'm not expressing a view one way beyond what I said in paragraph 93 as to amendments. Ultimately, as Mr. Shapiro says, it is up to you. Now, that's not to say, as I've said, that with the benefit of disclosure and expert evidence and so forth, there won't be either voluntary further particulars or amendments down the line. The question before the judge was, is this a plea that falls to be struck out or summarily dismissed? And he concluded rightly in our submission, the answer to that question was no. And there is a certain, in our research submission, lack of reality about some of the submissions that are being made. It's almost as if there had been a trial and it had been found that the policy in question was a liability policy and there was no liability on the part of Norman Hay to Miss Sage. All of those matters are matters to be considered as issues of fact at trial when considering the lost opportunity claim. As to is, with respect, ultimately the question of law as to what is required by way of proof in a claim by a client against its broker to establish the lost opportunity claim. But I'd said I would show my lords at least some parts of the pleading. I'll do that relatively quickly if I may, not least because my lords have helpfully been directed to some of these passages already, which I will largely skip over. It's the particulars of claim are at tab 7 of the core bundle, and the particulars of breach begin at page 86, paragraph 35. And my lords were showing this morning, that the allegations set out there allege that, first of all, that the defendant failed adequately to assess the claimant's needs, including failing to identify the type and scope of cover which the claimant needed and advise the claimant accordingly. Then there's the failure to recommend insurance policies that met the needs, those needs being directed towards the use of employees of hire cars in the USA. 3 is failing to arrange cover that met those needs. 4 is failing to advise the claimant that cover in respect of the use of hired vehicles in the USA had not been obtained. And then similar allegations on the renewal. Then at 6, a failure to consider the terms and scope of the IMP policy. And 7, an allegation that they recommended that the IMP policy be cancelled. There's an issue between the parties as to whether that was a recommendation that was made or not. And that's also in 8 as well. And then at 36, which I don't think my lords were showing this morning, some further particulars of matters upon which the claimant will rely. The first being that the defendant did in fact identify the need for insurance cover, or at least in any event placed cover that covered liabilities arising from employees hiring cars in the EU under the motor policy, and third-party liabilities arising from employees travelling but excluding liabilities arising from the use of motor vehicles under the travel policy. And again, just pausing there, that's another reason why we say we're under no obligation to, but in any event, why we don't narrow the case to a particular policy at this stage on particular terms, because here the position is rather more complicated than that, because there was in fact cover under the motor policy. For example, if Mr. Kelso had been hiring his car and driving it in Belgium rather than Ohio, then the worldwide programme for Norman Hay and its subsidiaries would have responded. Equally, the travel policy did respond, and we'll see in a moment in the reply. Interestingly, given the position that Marsh takes in its pleading, Marsh actually represented to the travel insurer, Chubb, that Mr. Kelso was an employee. And as a result, or in any event, Chubb, as the insurer under the travel policy, did pay out. It paid out death in service benefits of £100,000. So we plead then at 36.2, even without further inquiry, it was obvious that there was a need for cover in respect of the liabilities. Those liabilities being where employees, while travelling on business in jurisdictions throughout the world, including in particular the USA. So that's what we say at 35 and 36. Then at 37, the passage you've already seen, which is the one way or another plea.
Deliberately pleaded that the claimant and or IMP.
My Lord, yes, because IMP, we know, had cover under the policy that was cancelled. And so IMP is in a slightly different category to the other various different contingencies where we are looking purely on a hypothetical as to what may or may not have happened. We know, in fact, that but for the cancellation of the policy, IMP had €3 million of cover.
Which would have responded?
Which we say would have responded.
Even if there'd been no liability?
Well, would have responded either because IMP was liable or because of the type of considerations that we've been discussing, that there was enough being alleged for the insurer to take a view that it was likely to have paid out the indemnity. And then I'll come back to 38 if I may. 39 is the one where another point is pleaded again, and pleaded in particular by reference to the liability that the claimant discharged under the Sage Settlement Agreement, which is effectively an answer to the no loss point. And then, just going back to 38, the alternative cases, 38.1, as the judge noted, really is really not an alternative but further particulars, that effective cover would have responded to the liabilities arising from the accident, was obtained by the defendant for the claims of the group after the gap in cover was revealed by the accident.
Sorry, where's that?
At the top of page 89, my Lord, paragraph 38.1.
It says that the defendant was able to arrange cover in respect of the use of the hire cars by employees. Whose employees? The insured's?
My Lord, yes, because under that policy,
So it wouldn't cover Norman Hay.
well, except the insured's under that policy with Norman Hay and all of its subsidiaries,
So the subsidiary would be covered.
IMP.
Norman Hay would not, because the gentleman who died was not an employee of Norman Hay.
But then one goes back to the lost opportunity, which is not just we would have obtained
We
the
go back
policy.
to the lost opportunity, but you can't rely on this after the event insurance as showing that there would have been cover for Norman Hay as distinct from IMP.
What we can do is show that cover was likely to have been obtainable, at least as one of the alternatives, on the terms that was in fact obtained subsequently, and that supports the lost opportunity claim. Not just that would have responded for the benefit only of IMP, but you would then have had an insurer, as I put it inelegantly, on the scene, that even if the claim was brought against Norman Hay, or the claim for an indemnity under the policy was brought by Norman Hay as the parent in the group, a view would have been taken and said, well, look, we're not going to stand on the claims being brought by Norman Hay and not IMP, we're going to pay out. And that's the lost opportunity. And then at subparagraph 2 is the alternative case that IMP did in fact have cover, and with proper advice the claimant would not have cancelled it, and indeed would have instructed the defendant to seek such cover for the claimant and other companies in its group under the Global Insurance Programme.
So was the IMP policy, I thought that he pleaded or put in his skeleton that the IMP policy wouldn't have responded.
I think Malone Friend says that because it said that it would not have responded because Mr. Kelsall was not an employee of IMP, or there was an issue about that, and also because it's this pleading point. Because it's not been alleged in terms that IMP was liable, then the policy would not have paid out. And that's the backdrop that's really framed the debate that's gone on today, is the constant refrain of you have to pick, you have to plead who was liable to Miss Sage, and who then would have been beneficiary under the policy.
I think he says you've got to say, well, you haven't got to say, but unless you say that somebody is liable, you will not succeed because of the principle that liability policies only respond if somebody's liable.
And we say in answer to that that's not the approach on a claim against a broker, where you're looking at the lost opportunity, precisely because in a case of this complexity, the hypothetical as to what policy may have been in place and which entity may in fact have been liable is such that the client in the claim against the broker, as distinct from the insured suing under its contract of insurance with the insured, does not have to confine itself to one case that it was this company that was liable to...
Well, you don't have to confine yourself. You can say alternatively, if you want to.
Well, with respect, in substance, that's what our all or nothing case amounts to. One way or another, that's what we're saying. One way or another, it's either Norman Hay had cover and Norman Hay was liable, and therefore there would have been cover that responded, or it's IMP, in which case Norman Hay avoids the liability that it's in fact had to face, or, given a more commercial and pragmatic view of the situation, neither IMP nor Norman Hay nor any of the other subsidiaries under the policy that might have been put in place would ever have had to prove that they were liable to Sage, but instead Miss Sage's claim would have come in, a responsible insurer would have been on the scene and would have effectively taken over the carriage of the defence and would have settled the claim and wouldn't have stood on such niceties. And that's part of the opportunity that's been lost commercially. That's the value of the opportunity that's been lost. If there had been an insurer on the scene, that's why I described it, perhaps inelegantly, as I say, as a package of rights, because it's that's the opportunity that the broker's negligence has deprived its client of. Now, the position takes a further turn of complexity in the third subparagraph of paragraph 38. Because being a responsible insured and a responsible business, following the accident and having been made aware of the gap in its cover that the defendant had arranged for it, the claimant actually gave an instruction to its employees to ensure that when hiring cars on business trips, the maximum available insurance cover, including for third-party liabilities, was obtained, and that private hire vehicles were to be used wherever possible. So, again, looking at the hypothetical, even if contrary to the foregoing case as to cover being in place in the hypothetical in one way or another, then, but for the defendant's breach of duty, a similar standing instruction would have been given prior to the accident, so that the liabilities to Miss Sage would have been one way or another avoided. And that's what then feeds into the one way or another plea at paragraph 39, and also reflected in at paragraph 39, and then the loss of a chance claim pleaded at paragraph 41. Now, just briefly on the reply, to make good a submission I made earlier. In the reply at tab 9, page 122, we have first of all paragraph 21, reference to the Chubb travel policy, where claim was presented under that policy, which was again a policy for Norman Hay and its subsidiaries, and Chubb and Marsh, forgive me, dealt with that claim, and you'll see what Chubb said to Chubb about the accident, namely that Mr. Kelso was an employee of IMP, and Chubb subsequently then paid out under the terms of that policy. And I think finally, for present purposes, at page 130, paragraph 63 in the reply, some further particulars of what happened after the accident in terms of the placement of further cover by the defendant. And so drawing those various threads together, my lords, that pleaded case plainly gives rise to multiple issues of fact, including as to what cover would have been available on what terms, what is a proper analysis of Miss Sage's claim, and who were, or might have been liable to her as a matter of Ohio law. What would the attitude of the insurer have been under the putative policy? And so forth. And we say, with respect, that's a perfectly sensible pleading with a real prospect of success. It may or may not succeed at trial, as my Lord Master of Rolls has said, but it is a pleaded case that is capable of and should go forward to trial to be determined on the facts. Now, my lords, just returning to...
And I suppose you can say that they have not pleaded that IMP was not liable.
My lord, that must be right. Or indeed in terms, I think, that Norman Hay was not liable. That they only take the pleading point. You, the claimant, must plead that Norman Hay was liable. And then I think they probably have a fallback point that they don't accept that a plea that IMP was liable would do the trick. But even if it did, they say you haven't pleaded IMP's liable either. And that they themselves do not plead a positive case. And Norman Hay was not liable, IMP was not liable, therefore no liability cover of any type would ever have responded.
I suppose your point is you've lost the chance anyway. Because, I mean, I suppose you can say, well, I don't know if they were liable. I don't know what happened in the accident. I don't know the details of where he was the night before and what he was doing. And he's dead. I can't inquire of him. We've sold the company. I can't inquire of other employees and so on and so on. But you say it doesn't matter. I've lost the chance that it would all have come good and insurers would have done the decent thing.
My lord, exactly. And that's why in a broker's case, the client is not required to go to the same lengths as is required perfectly sensibly in a case where an insured is suing its insurer. Because in the broker's case, the client has been deprived of the opportunity.
But is it then your argument that it is different? There is a material difference between saying that you won't allege that IMP was liable, and Norman Hay or IMP, for the sake of argument, and his saying that you cannot succeed unless you do say they were liable, because you say it may be a defence for him to allege and prove that insurers of the policy that you would have put in place would not have responded. That might be a defence. You accept that.
But
if he could prove that. But it is not doesn't automatically knock your case out of the water if you fail to allege that they were liable.
My Lord, with respect, yes. And
That's quite a nuanced but maybe important distinction.
well, my Lord, it does come from the principles that we say fall to be derived from the authorities. And I'm going to.
There's only one authority binding on us, and I'm a little bit hostile to the 30-paragraph analysis of Delbad on different facts, or whatever it's called. But the one that's binding on us is Fraser.
Yes.
And in Fraser, the court was asked to decide the question of whether the policy would have responded. And it decided the policy would have responded as a matter of law. In other words, whatever it was, an exclusion wouldn't have been, right? But that's not this case. In this case, on the pleading, you say, I am not obliged to say what the factual position was in Ohio in that case as to who would have won. If you can prove that there was no liability and the policy would not have responded, well, that may be a defence, but you haven't pleaded that either.
And my Lord, that is entirely consistent with Fraser. And the important passages in Fraser are, I know you've looked at these already, but can I just invite my Lord to return to the Authorities Bundle tab 1, and it's page 9 of the Authorities Bundle. Because before considering the 2 points that my Lord the Marshal Rolls has just identified, Lord Diplock in this case deals with the position as a matter of principle. And if one starts at 904 of the report, letter B, the breach of contract in not obtaining an employer's liability indemnity policy is admitted. The employers are accordingly entitled to be put in the same position, so far as money can do so, as if the contract had been performed by the brokers. No question of remoteness arises. If the contract had been performed by the brokers, the employers would have been parties to a policy of insurance against employers' liability in standard form, underwritten by a first-class insurance company of the highest reputation. As a result of the breach, they were not insured at all. And then with this at D, what damage they have suffered does not depend upon whether Eagle Star would have been entitled as a matter of law to repudiate liability under their standard policy, but whether as a matter of business they would have been likely to do so. What the employers have lost is the chance of recovering indemnity from the insurers. So what the client of the broker has lost is the chance of recovering indemnity from the insurers. And then, and that's important, the starting point is loss of a chance. Then his lordship goes on to say, in considering that lost chance, if Eagle Star would not have been entitled to repudiate liability in law, some impermissible Latin, codit quaestio, i.e. the question simply doesn't arise.
We sort of understand a bit of Latin. We
Well, no,
tend not to.
I was grasping desperately for my GCSE Latin and hoped that would just about pass muster. But the question doesn't arise. The damages recoverable would amount to a full indemnity. Now, pausing that, that's because in that case, it was accepted that given competence, there would have been this particular policy in place, it would have been with Eagle Star, it would have been on these terms. The defendant was contending, by way of causation defence, yes, but even if you've got that policy, for reasons unconnected with my breach of duty in not arranging it, the insurers would have been able to repudiate. And the analysis by Lord Justice Diplock is, well, in evaluating the lost opportunity, I have to consider the defendant's causation defence. If, as a matter of law, the causation defence never would have arisen, end of question. The question doesn't arise. And you're entitled to a full indemnity because you've established, or it's been accepted, that you would have got that policy in any event. if arguendo, the defence might have been available to the insurer, then one goes on to consider, well, would it have been taken? And in that case, it being a relatively short point of contractual construction, the question was decided on the balance of probabilities. But that's in determining the defendant's causation.
Well, the question wasn't, as my lord said this morning, decided on the balance of probabilities. It was decided,
forgive me,
as a matter of law.
Forgive me. And it precisely so. That's what the Court of Appeal was not doing in that case. Was deciding, as a matter of law, what cover would have been in place or not. It was deciding whether, so to speak, the defendant on its causation defence even got past.
Well, the distinction in this case is that in this case it was accepted what the policy would have been and what the terms of the policy would have been if it had been placed as it should have been. Right?
Yes.
So the negligence, the breach of duty was clear, what you should have done, and everybody accepted that was what would have happened if the duty had been performed. But the more difficult analogy with our case is the two stages which he dealt with, because he actually said, as I understand it, but you'll correct me if I'm wrong, because it is slightly compressed, this reasoning. He actually said, if the insurers, in relation to the policy which would have been placed if the duty had been performed, could have avoided liability under the exclusion, or whatever it is, the clause, that's not the end of the matter. It still, you have to consider what would have happened in practice, because insurers generally take bad nasty points like that. Insurers first class, I mean, this sort of, we slightly have to read this through the eyes of the era in which it was written. But anyway, insurers don't take bad nasty points like that, and there may still be an argument that you would have had some coverage which would have been valuable to you, and you lost a real chance, a valuable chance. That's what he says.
Yes.
And here, I think Mr. Shapiro accepts that the same applies, namely the first question, he would say, the first overall strikeout question is, did Miss Sage have a good claim against somebody? And if she did not, he says that there's no loss of a chance because you've shown she didn't have a good claim, so you haven't lost it. So there's no chance here. But you say, you may be right, but you're only right if you can prove that she didn't have a good claim, not requiring me to allege that she did have a good claim. It's not the way the judge put it.
Well, it's the effect of his analysis of Dalland, and the reason perhaps that there are so many paragraphs dealing with that particular authority is that was the focus of the submissions below and in the way.
Dalland, I mean, we can look at it if we absolutely have to, but Dalland is a different case again.
It is. With
different facts. I had them in my mind when I read all this, but I've forgotten them now, thank you, but you can tell me if relevant. But you're right, it's Dalland. I mean, that may be why he had to have so many passages. And he said, well, I don't necessarily agree with every bit of Dalland, but the textbook has got it right in commenting. He didn't say that Mr. Justice Butcher was wrong. He just said he may have expressed himself in not completely clear terms, I think is really what he was saying.
Well, and in any event, as my lord identifies, that was a different case to this.
A different case.
Because here, as I think he said, Mr. Justice Butcher effectively left the door open for it. If the broker's effectively deprived you of having an insurer on the scene at all that you can sue, different considerations apply, because as the judge identified, the rationale for the approach in Dalland was that you were dealing with matters of historical fact rather than hypothetical counterfactuals.
Yeah.
And my lord, what one also sees from some of the other authorities, this distinction between the lost opportunity that the claimant has to prove as against where a defendant raises a causation defence. And can I just identify what we say the principles are that come from the authorities, and then we might quickly just look at some others, because having looked at Fraser and sought to explain it as I have, we may not have to go to very many of the others. Now, I think, doing the best we can, we think that there are probably four principles that we can derive which support our case. That there is then a fifth, which we can come to if necessary, which explains the position in Dallas. The first is that if and we're dealing here only with obviously the broker's cases, a claim by a client against the insurance broker.
Yeah.
If the client can establish duty and breach of duty, then as a matter of causation, it must establish that it lost the opportunity of having in place, but for the breach of duty, insurance cover with an insurer that would or might have provided an indemnity in respect of the third party claim. Second and following from one, a claimant client suing its broker does not have to plead and prove that it was contractually entitled to an indemnity from its insurer or putative insurer, in turn requiring proof of an actual liability to a third party falling within the terms of the policy, in order to recover damages from the broker for failing in breach of duty to arrange cover. Third, whether or not a policy would or might have responded will be a relevant issue within the loss of a chance analysis without supplanting it.
Without what?
Without supplanting it, without supplanting the loss of a chance analysis. And we see that in our submission from the passages in Fraser that we were just looking at. And we do say, as set out in our skeleton, that the authorities, including Fraser and from Fraser onwards, are clear. The fact that when applying the loss of a chance analysis, the court may make a finding that the policy would or would not have responded does not elevate that issue to a requirement, still less a requirement that the claimant must plead and prove.
Yeah.
Nor does it establish the two-route approach to causation suggested by the appellant. Fourthly, and flowing from 3, in particular, the court may make findings about whether the policy would or might have responded in considering whether the claimant client has made out that it lost the opportunity of securing an indemnity from the or an insurer. Indeed, the position may be so clear that not only does the claimant establish the loss of opportunity, but also that there was effectively no chance of it not securing an indemnity, so that no loss of a chance discount is made and the client recovers in full. Indeed, contrary to submissions made by a learned friend, that was the outcome in one of the authorities to which both parties referred, Dunbar, where, although the judge at first instance occasionally expressed himself as deciding the position on the balance of probabilities, the Court of Appeal found, this is tab 3 of the authorities bundle, we need not turn it up, but the Court of Appeal found that effectively he should have applied the loss of a chance approach, and that in substance he had, and effectively concluded that the chances of the client not recovering their indemnity were nil. So there was 100% recovery.
Or the converse. So the chances of the policy responding may be so slight that they can be discounted altogether.
And that's why the claimant bears the burden of showing a real as opposed to a fanciful chance, because if there's no real prospect of it being able to obtain a payment from insurers, by one reason or another, then the claim would fail as a matter of causation. Now, we say that all flows from Fraser, Everett, and Dunbar, which I've just referred to. And of course, it was the approach that was applied in O&R Jewellers, tab 4 of the bundle, the authorities bundle. And it's because it was the approach that was applied in O&R Jewellers that my learned friends were originally driven in their skeleton erroneously to suggest, oh, well, that first instance decision can be explained because the judge was led into error by not considering.
By counsel.
Well, no doubt by counsel, had it been true, but it wasn't. But by not being asked to consider Fraser and Dunbar. And, of course, the position was that the learned judge was taken to Fraser and Dunbar, and indeed addresses both authorities in not some little detail in the course of his judgment, beginning at page 41 of the authorities bundle behind tab 4, in the report, page 445 of the report, column 2, where just after the red lining that learned friends have placed on the authority, the learned judge says the correct way of assessing damages in a case such as this has been considered in 2 reported decisions of the Court of Appeal. The first is Fraser. And he then goes on, over the rest of that column and over the page, to consider the decision of the Court of Appeal in Fraser, before at the top of page 446, column 1, turning to the second case, namely Dunbar. And he then, over the rest of that column, and over to the top of page 446, column 2. So there was a detailed consideration, as with respect one might have expected, given the identity of counsel in this case, of the 2 relevant appellate authorities in the area. And the learned judge then went on to conclude, in both these cases, it was undisputed that if the brokers had performed their duty properly, their clients would have had the benefit of a valid policy. In the present case, as I've said, that is in dispute. There appears to be no reported case in this country in which the court had to deal with a dispute on that point. I have, however, been referred to the decision of the Court of Appeal of New Zealand in CB Marine and Lombard. The learned judge then considers that, which one will see, if necessary, at page 447, considered the approach as a matter of lost opportunity. And the judge then concluded, having cited from that authority towards the bottom of column 1 on page 447 of the report, with this I respectfully agree, i.e. application of a lost opportunity case, I see no reason why the principle stated by Lord Diplock in Mallet should not be applicable to the question whether, if the broker's duty had been performed, the client would have obtained a policy at all, just as it applies to the question whether, on the same hypothesis, he would have succeeded in recovering under a policy which admittedly he would have held. And so, having found consistent with authority that it was lost opportunity that was the relevant approach to whether there would have been a policy at all, he then went on to consider how that lost opportunity was assessed. And if one looks at the bottom of page 46 of the bundle, column 2, the very last 2 words, the relevant question is not whether the underwriters would have taken each of the other defences in isolation, but whether in the absence of primary defences being those given to them by the broker's breaches of duty, they would have taken together all the other defences which I have held they would have had available. I'm satisfied that they would. I say this for 3 reasons. And he then goes on to assess the overall value of the opportunity lost. And one sees that column 2, page 451 of the report, at the last, the penultimate paragraph, I address the final question. What is the chance of recovering £850,000 of which the plaintiffs have been deprived by the second defendant's breach of duty? This question covers all the uncertainties which I have discussed. Uncertainties whether, if there had been no breach of duty, the plaintiffs would have got insurance and on what terms. If they had, uncertainties whether their claim would have been compromised or fought to a finish. If compromised, for how much? If fought to a finish, with what result? I do not consider that the right course is to try to evaluate each of these possibilities separately. It is rather, as Mr. Justice Kerr said in Everett, which we have at tab 2 of the authorities bundle, to take into account all the ifs and buts and come to a comprehensive estimate of the chance. And having done that, he evaluates that chance as 30%, giving my Lord the Master of the Rolls his victory in the sum of £255,000. Now, my Lord, the reason why, no doubt, my learned friends felt they had to try and explain that case is the approach of the learned judge based on the authorities in that last paragraph which I've read is exactly the approach that reflects our pleaded case. All the ifs and buts have to go into the consideration of the value of the chance lost. And that's why it's not only not necessary for a claimant to go to the lengths that the learned friend suggests one has to in pleading who it was exactly was liable to Miss Sage and which policy it would have been that would have given rise to an indemnity. It's also inappropriate to confine a claimant in its claim against its broker to such a case, because to do so does not fairly reflect all the ifs and buts as to what may have happened. And while there were, if I may say so, a perhaps unusually large number of ifs and buts in that case, as my Lord the Master of Rolls recalls, there are perhaps even more in this case, given what we've seen from the pleading, as to what had already happened, what the response to the accident was by Norman Hay and its subsidiaries itself, and what happened subsequently thereafter in terms of claims under the travel policy, the existence of cover in the EU, the placement of cover under the programme that was designed to meet the very liabilities that had arisen, and so forth.
How does it work on your case, in a case where, as sometimes happens, you have a claim in the same action against the insurer and the broker, and the insurer, the underwriter, is called, and he says, well, I can't be sure, but on the whole, I think I would have taken that point, and the judge accepts that evidence and finds on the balance of probabilities, but only on balance, that the insurer would have taken the point, and therefore the insurer is not liable. Do you then go on to assess loss of a chance against the broker? Or how does it work?
Well, I think it's right that that's not an issue that has fallen for determination in any of the authorities that we have before the court, or perhaps any authority. Of course, in that case, because the insured is bringing a claim against the insured, they would have had to have committed to the claim against the insurer to a particular case which it said, it's the insured, says gave rise to liability on the part of the insurer under the policy. And it will be that case that would have then been considered at trial. Now, that's not to say that a broader case could not have been made against the broker.
But the argument would be a completely different one, because the argument would be broker did put in place a policy. The policy maybe didn't respond because it had an exclusion which the underwriter may or may not have argued about. But then you're looking at really the way in which the policy probably was negotiated and whether the exclusion ought to have been excluded and so on. So it's a rather different kind of case.
Well, that's really where.
I mean, I agree it is different because it assumes that there is a policy in place. So.
Well, I think, with respect, my Lord, I think it goes beyond an assumption. In that case, there was a policy in place with an underwriter you could go and cross-examine. I mean, here, of course, you don't have that. And that's where, having identified the 4 points that I have from the authorities, there is a fifth, which frankly, we can stop after point 4, and having looked at O&R, as we have done, and make the point that our case is in accordance with those principles, and they are, of course, as my Lords will recall from our skeleton, all reflected in the way that we say they are, and as recorded by the judge, as they are in the practitioner text. That this is how you go about pleading your loss of a chance and proving your loss of a chance in a broker's case. So we could stop there. But there is a fifth point that comes from the authorities, which I think I should address my Lords on, because I think it does go to the hypothesis that my Lord Justice Miles just puts to me, which is that it's clear from these authorities too that the court may also make findings about whether the policy would have responded where a policy was in fact in place and the insurer was entitled not to provide indemnity by reason of a breach on the part of the broker, but where the defendant broker advances a causation defence to the effect that cover that was in place would not have provided an indemnity in any event for a reason unconnected to the broker's breach of duty. And that's a case like the one that my Lord Justice Mayles puts to me, and it's also a case, of course, like Appellant. In substance, it might be thought that in such a case the defendant is arguing that there is no or no more than a fanciful prospect of the claimant being entitled to an indemnity for the reason unconnected to its breach. And here, it being a causation defence, the defendant bears the burden. And that's a point made in Dunbar. In such a case, you obviously have a policy that's in place, which is a fundamental point of distinction between this case and the type of example we're considering. And in such a case, the claimant can either show, or it is accepted, as it was in some of these authorities, that it did have at least a more than fanciful chance of having an entitlement to indemnity, but for the defendant's breach. And the defendant is not attacking the existence of that opportunity per se. Instead, what he's saying is that the existence of that opportunity, the opportunity to recover an indemnity from the insurer, but for the defendant's breach, would have been trumped, probably should have chosen a different word, would have been trumped by the separate ground under the policy that was in fact in place, entitling the insurer to decline indemnity for reasons unconnected with the broker's breach. But my lords, we don't have to go that far to hold on to the judge's judgment. It provides a further explanation of why he was right. Indeed, it is effectively the explanation he gives as to why this case is not a damned case. Where we need to go and stop is covered by the first four principles that I've identified. And if one looks at, and with respect properly analyses the authorities, this is not a Dallam case, and the judge was right so to hold. And he was also right to hold that this is a lost opportunity case where the relevant opportunity has been properly pleaded, and where that lost opportunity gives rise to all of the various contingencies he identifies in paragraph 84 of his judgment. And my lords, having now gone through the pleadings and the principles we say ought to be derived from the authorities and identified the various complexities in the contingencies here, I hope that I've now explained why it is that we plead the case as we do, and why we say that that pleaded case includes various of the matters that we've been talking about as to liability, but that the lost opportunity case gives rise to a multifaceted factual inquiry as to what the correct hypothetical would have been and the various contingencies within it. And our plea seeks to embrace and cover those various different contingencies, which give rise to some of the issues, of course, as to liability and as to what terms of the policy may have been and so forth. But we are not confining ourselves to a case, and should not be confined to a case, where we have to pick a particular contingency and say that's the one, because that's not the opportunity that we've lost. My Lords, having, I think, made those submissions, I have effectively addressed, well, that's not for me to say, I think I've effectively said all that I wish to say about grounds 1 and 2 already. Insofar as grounds 3 and 4 are concerned, I think I can take the position shortly. Ground 3 is that there's no pleaded loss of a chance case. There is, and the judge was correct so to hold, in particular paragraphs 91 and 93 of his judgment. Ground 4 is that the judge was wrong, it is said, in failing to assess the merits of the loss of a chance case. My Lords, that is itself premised effectively on grounds 1 and 2 and the pleading points, because if there's a loss of a chance case pleaded with a real prospect of success, and we don't have to do that which the learned friend says we have to do, then really ground 4 doesn't get off the ground.
So ground 5 is a separate point on reflective loss.
Ground 5 is a reflective point on reflective loss. We deal with it in the skeleton at paragraphs 59 and following. With respect, I was going to say it's really quite difficult to understand the appellant's argument here. That's not fair. One can understand the argument. With respect, it's quite difficult to see how that argument that leads to the suggestion or supports the suggestion that the judge's analysis was wrong, where he found that there is a claim with a real prospect of success here that ought to go to trial as to whether Norman Hay has suffered a loss. Now, it is true, and we accept, that the position is slightly more complex here in that the mechanism by which the Sage settlement came to be paid was not as straightforward as Norman Hay writing a cheque or sending a bank transfer to Miss Sage's lawyers in Ohio, but instead the Sage settlement sum was funded by the sums that were held in escrow. As Malone Friend helpfully identified, under the settlement heads of term, and we say the settlement agreement, it was Norman Hay that was obliged to pay Miss Sage the settlement sum. One sees that in particular at clause 10 of the binding term sheet. I'll just give one Lord's authority. The reference, supplemental bundle tab 6, page 198, at page 200. And as we've pleaded, had we not lost the opportunity that we did, then the Sage settlement sum would have been paid by an insurer. And there would have been no need for Norman Hay to be paying the Sage settlement sum at all, whether through the mechanism of the escrow account or any other mechanism. And indeed, for the completeness, an equivalent analysis applies on the alternative case that liability to Miss Sage would have been avoided because the standing instruction would have been given and Mr. Kelso would have used a private hire vehicle. So again, it goes back to the one way or another point. One way or another, Norman Hay would not have found itself paying the Sage settlement.
But it could be argued that the SPA is a break in the chain of causation. It could be argued.
It could be argued. It can't be said that that provides the knockout blow, which is what's required for summary judgment.
Well, it's not said. It could be argued that it does.
No, and I'm not sure. I'll be correct. I'm not sure if it's even pleaded, but that's not really the basis upon which the application was put before the judge.
No, but what's said is what you're actually claiming is there was a liability of IMP. Well, that's what he wants you to claim, but you're denying, you're refusing to. And that the reason Norman Hay paid is because it suffered reflective loss, which is not claimable, although I notice no reflective loss of authorities in the bundle.
No. And I mean, the short point is that's an argument for trial. As the judge said, he was satisfied.
And I suppose you say, do you, that there was a duty to you to advise about cover for your subsidiaries as well as for you, and you were both sued, and as a result, if the chain of causation is not broken by the arrangements you entered into, you ended up, anyway, as a matter of practical reality, paying for what an insurer would otherwise have had to pay.
Exactly. It's the one where another point is that if the defendant had discharged its duty, Miss Sage's claim would have been dealt with.
Yeah.
And because of their breach of duty, we've had to deal with it. And all of the various arguments, I mean, there was an argument maintained below that somehow the buyer had actually paid the Sage settlement sum. It wasn't the buyer. The buyer put some of the, or required some of the purchase monies to be held in escrow. And there was a joint instruction from the buyer and Norman Hay, because a joint instruction was required, as usual.
Yeah, but I mean, his point is that actually the practical reality is all that happened is you got less for the subsidiary because of this claim. But that presupposes the point about IMP being liable.
My lord, it does.
And I suppose that's why you're not prepared to say IMP was
Well,
liable, because he will then say, "Aha, I got you."
I think my own friend says that anyway. But the short answer is really the one the short answer is really the one that I've sought to give, which is that had the defendant discharged their duties, Miss Sage's claim would have been.
But even in cases that have that short answer, the reflective loss principle can destroy you, which is why I would have expected to see all the lovely authorities that have emanated from the Supreme Court in recent years on this subject in the bundle, but we haven't.
And indeed, most recently, the Privy Council, I think, in Premier.
Yes.
Where the
I was including that one.
Yeah, no doubt what it was. Where the position has changed again, but that's not the way the claim the argument has been advanced in support of what is a summary judgment and strikeout case. And the question for my lords with respect is, can it be shown to the requisite standard that the judge was wrong to say, well, I'm not satisfied with this claim?
Well, you say it's eminently arguable if you get as far as that.
Exactly.
Yeah.
I thought the judge thought that you had disclaimed that. In other words, paragraph 55 of the judgment. I mean, I wondered why you disclaimed it, thinking along similar but less articulated grounds than the Master of the Rolls has just said. But it looked as if that was the judge's impression. Is that wrong?
We don't say that we are seeking to claim the diminution in the value of our shareholding. That's not the claim we bring. Nor do we say that and this is the alternative way it's put, that somehow we're trying to claim the loss suffered by AMP or Mr. Kelsall's estate. What we say is that this is a loss suffered by Norman Hay. The loss suffered by Norman Hay was the lost opportunity of not having this cover with a putative insurer in place.
Okay, well, you've said that, but I'm a little bemused by the contrast between the first sentence of paragraph 53 and the first sentence of paragraph 55. But perhaps my lord will explain how they fit together later.
Well, I think the explanation is in paragraph 54 of the judgment.
Yeah.
And that's the way we put it.
Yeah.
And the judge effectively concluded that claim stood a real prospect of success, and it does.
Okay. Good.
And my lord, I don't think. And of course, just before leaving ground 5, of course, at paragraph 59, on the submissions that were presented to him, the judge concluded rightly that the loss issue effectively stood or fell with the liability issue. Ground 6, I think we've probably dealt with sufficient in the skeleton, but the points there are that, one, the appellants can't really have their cake and eat it, that they say both that the judge was wrong to determine the points of law as he did, but then complained that he didn't determine them. And in any event, we say that where the judge had to dispose of points for the purposes of, or had to determine points for the purposes of determining the application that was before him, he did so and was right to do so in the way that he did. And where he didn't, he rightly left them for trial, as is the conventional approach. Well, that's all I was proposing to address.
Thank you very much. Thank you. Yes, Mr. Shapiro.
My Lords, the answer, certainly up till today, to the question posed by my Lord Justice Males, of are you asserting that either Norman Hay or IMP was legally liable to Miss Sage, has been a resounding no.
It's maybe, I think, actually.
Sorry?
I think it's maybe.
Well, that
They're
would
not
be
making the express. They're not making that express content. They're not putting forward that express allegation, pleading and accepting the obligation to prove it. Yes.
Well, maybe is a significant change for two reasons. One, if he had simply said that he was asserting that Norman Hay and IMP was liable in law to Miss Sage, we would not have brought the application. Secondly, if he had said that, and we specifically checked at the CCMC, which my learned friends insisted followed hard upon the heels of this, the first instance hearing and before today, we would have got Ohio law expert evidence, which we specifically have not got, because my learned friends specifically said they were not seeking to prove, as a matter of Ohio law, that either IMP or Norman Hay was liable to Ms. Sage. And it was remarkable to hear from my learned friend just now that he intends to have as an issue at trial whether they are liable under Ohio law. The Ohio law is not pleaded. It's never been said that that's their case. There was no issue on the list of issues. It's unfortunately not in the bundle, but there wasn't one at the CCMC, and we don't have Ohio law expert evidence because this was not an issue. Until today, it was a resounding no. And
Okay.
in my submission, I'm not sure where maybe leaves.
I completely understand that, but can you tell me your answer to the point I put to Mr. Chapman, which is that it isn't enough potentially, even if he doesn't plead liability by Norman Hay and or IMP, and it's not enough for you simply to say you haven't alleged that and therefore you have no case. You have to actually plead and prove it to defeat the case.
There are two answers to that, my lord.
Which are?
The first is we have pleaded the point in the defence, and I'll take your lordship there now. The second is...
Well, you have pleaded it, but even if you have, you haven't proved it yet. It's not admitted.
I accept that. In that case, there are three answers. And there might be a fourth still to come. So the first answer is that we've pleaded. And may I show your lordships what we've pleaded? It's on page 106 of the core bundle. Paragraph 63, we say the claimant has failed to identify whose liability Ms. Sage is referring to. Liability policies covering the claimant will only indemnify the claimant in respect
Sorry,
of
you've got to let me find it. 63.
Sorry, I'm so sorry.
Paragraph 21 is embarrassing. Right. Is that right? The claimant has failed to identify whose liability is not covered. Liability policies will only indemnify in respect of claimant's legal party. Yeah. And that's not a pleading that one was liable.
Well, necessarily,
liable.
absent such liability, the claimant is not entitled to indemnity.
Well, that's not the point I'm making, is it? The point I'm making is the reverse of that.
And
I mean, I know you say that in the absence of their proving liability they fail. What I'm putting to you is that that is not the case because of the way he's put his case in his argument today, and that if you're wrong about that, the only way you can defeat the claim on the grounds of an absence of liability is by pleading and proving an absence of liability yourself.
well, I know that that's how it's been put today for the first time.
Yes, and it goes in the court.
The three responses are:
yes.
A, we've pleaded at 63 that the claimant is not entitled to indemnity because it's not established that. Now, I'll take your lordship to the authorities in a minute on who bears the burden as between claimant, insured, and insurer of establishing liability.
Yeah, but it's not to do with as between the insured and the insurer. This is to do with as between a broker and his client. And what Mr. Chapman says is that's an entirely different matter.
Well,
It's not, I don't have to assume the burden of proving every last thing that would have happened in order to establish that I've lost the chance of cover. And if I'd had cover, I would have stood a chance of getting a payout. It's completely different as between insurer and insured. We know that as between insurer and insured, we know what the position is. We've seen all the authorities. We knew it even before we saw the authorities.
so the third point, which I'll
Yeah.
come to, but I do want to finish the first two, is that the usual position should apply as between the claimant here and a broker, not least because the position is, as they are perfectly entitled to do, they are asserting privilege over all the legal advice and all the details of the settlement they've entered into with Miss Sage.
So what?
Sorry?
So what?
So what? In order to plead more than we have done, is impractical. We've said on the face of it, for example, in relation to 64, we've said, we've explained Mr. Kelsall was travelling on Thanksgiving morning, not alleged he was travelling in the course of his business. It's to be inferred from the date, time, and location of the accident that Mr. Kelsall was not travelling in furtherance of IMP's business at the time of the accident. And then we take the point that it's not alleged.
Where's that? Pleaded, sorry.
I'm so sorry. Paragraph 64B.
64, yes.
Still on page 106.
Yeah, no, I see. Okay.
And then we can.
So you plead, you say you plead as much as you can, but you can't plead any more without them waiving privilege. They're not prepared to waive privilege, so there we are.
Yes, we're pleading a positive case that, on the basis of what we know now, it's to be inferred they're not liable.
Yes, but you haven't proved it.
I'm sorry. Yeah, we haven't proved
accepted it. You haven't proved it, so it's a tribal issue.
Well, it would be a tribal issue if they were able to say to this court, here are the reasons, or here is even one reason I say that IMP is liable to Miss Sage.
Well, I mean, it's not difficult to see one reason why IMP might be liable to Miss Sage.
Your argument in this court is not that IMP is not liable because he wasn't an employee or because he was on a frolic of his own, but that they're not liable at all because, they must, subject to those 2 points, IMP must be liable unless the law of vicarious responsibility is very different in Ohio from what it is here, and nobody has pleaded that.
And we assume it's not. Unless somebody...
I accept the point being made. But it's the argument. what we're saying is, because it's not alleged that IMP was legally liable to Ms. Sage, and for whatever reason,
Sorry, because it's not.
I'm so sorry, because it's not alleged in a particular claim that IMP was legally liable to Ms. Sage, for whatever reason, we still haven't got the reason. The reasonable inference is that it wouldn't have been. What basis can the court go on, except that it wouldn't have been alleged to the insurer? There's a reluctance to say there's any liability.
Well, of course, it would have been alleged to the insurer because they say we've got this great complaint emanating in Ohio, which says everybody's liable. Help! If we are liable, please pay. That's what clients say, when insureds say when they get a great big writ in Ohio or anywhere else.
Well, my lord, for whatever reason, it's not being alleged. And at 17...
Well, we know that. We know that. But the point I'm putting to you, I know you know the point, but it does seem to me to be something that needs to be answered, is that their case stands up, even on your case, unless it is proved by somebody that there was no liability, could be no liability under the putative policy. And you say that, but you haven't proved it yet. So it's got to be a trial.
Well, I accept, plainly I accept I haven't proved it yet. In my, the two positions that the court has at the moment, just to complete the pleading point, if I can ask my lord just to look at paragraph 69B over the page on 108.
Yeah.
It is relied on the claimant does not plead that either the claimant or IMP was liable and nor to mistake. It is accordingly inferred and averred that neither.
Yes, well, that's a great pleading.
Well,
but it's not succeeded yet. May succeed.
And there's similarly 76B if we're looking for the pleading. But in terms of where we are, we're pointing out that it's not pleaded, and the reasonable inference is that there is no liability.
Yeah.
They're refusing to assert that it is.
Yes, well, we get that.
They're offering. So on it's either a very perverse or a perverse refusal just to say yes.
But I
or
thought
there's
that
something
Mr.
behind
Shapiro.
it.
I mean, I thought that, which is why I put it to him in such robust terms that he ought to tell me. But he says, no, it's not perverse, and I think I'm beginning to understand why he said it wasn't perverse. He said, I don't have to say this is the way that you become liable to me. All I'm saying is you're the expert. It was your job to advise me and get cover. That's what I asked you for. You didn't get it. I don't have to tell you, hang my hat on one possible explanation as to how I've lost things. There may be several explanations as to how the route to loss. And it's good enough for me to say, one way or another, I would have had the chance of cover. Thank you. Pay.
Well, nobody's limiting murder friend to one plea.
Well, no, I put that to him too. I said you can say and or. But he doesn't want to do that. The question is, does he have to?
Well, if he wants to contend that the easy example to why it should be pleaded is we've now gone through the CCMC and we're, unless its application succeeds in this court, going to trial without any Ohio law expert evidence.
Yeah. It's a troublesome little case, isn't it?
Well, it didn't need to be. If the reality was maybe we're saying they're liable, but we don't want to be restricted to that, why not say it in response to the question asked? Why not say it at the first instance hearing? Why not say it before prompted by my lord?
Well, I think he's given an answer. It may not be entirely compelling, but it is at least intelligible.
And the answer is that it's not not necessary for the client to plead and prove that it is liable to the third party, was what I wrote from the transcript.
I mean, he may have in mind, in not wishing to say something, he may have in mind the privileged advice, which he may say would give you the possibility of claiming a waiver of privilege if he came off that fence. I don't know how, but I'm just speculating. I mean, there's all sorts of reasons of what things that have gone on that might lead him not to want to put his colours to the mast. I mean, the most important one for our purposes is he says he can succeed without doing so.
Yes, although he's then limiting himself to route 2 in my submission of Fraser and Furman.
Well, he's definitely limiting himself to route 2, i.e. Fraser route 2.
Once one's limiting oneself to route 2 of Fraser and Furman, the next question is, does he have a substantial prospect of success?
Well, that depends on what the issue, that may depend on what the case looks like, which may mean that there has to be some analysis at trial about that.
Well, if he's not going to allege liability, the starting point...
Well, he did settle for $5.5 million, which sort of looks like a bit of accepting liability.
Well, it means that one of the defendants accepted liability, and that one of the defendants...
Yes, but I mean, we're talking only about Norman Hay Group defendants, aren't we?
But they've ceased to be part of Norman Hay Group.
No, I know. But that was dealt with in the SPA.
So it was the new group who paid the 5.5
Yeah,
US.
but that's because of the SPA machinations.
Well, they would have had to. They would have had to pay that anyway. The SPA machinations resulted in that payment reducing the purchase price.
And there is some other point, isn't there, Mr. Shapiro, about what happened afterwards? The cover that he pleads that points to there being a type of insurance that would have responded in practice.
No, because what he says is that a liability policy was obtained afterwards. His case throughout has always been a liability policy.
Well, I know, but there are liability policies on. I mean, there are liability policies and liability policies, right?
Well, it's an English law liability policy on standard terms.
Well, I don't think he says that, because he says it would have responded here and would have led the insurers to defend. I think he said that.
He's said that today, but he hasn't pleaded that.
I think he did actually, but okay, it was difficult. Yeah.
The second part of my answer to my lord's questions is that on the in terms of the position that the insured is left in on causation, the insured, if it had had the policy, would have had the burden of proof, and therefore I do say that the burden is on my learned friend to plead and prove its liability, because that is exactly the position it would have been in had a policy been in place. And may I make that good, please, from the authorities bundle, tab 5, page 58, which is from Mr. Justice Aiken's judgment in Enterprise Oil and Strand. That's paragraph 27. The first principal question is, what does Enterprise have to establish in order to obtain indemnity under the policy? This issue is governed by English law. When an insured makes a claim under a liability policy, it has to demonstrate that it has suffered a loss by virtue of a legal liability, which has been ascertained. Yeah. So the burden is on the claimant to plead and prove that. And then, if I can pick up both omega proteins and AstraZeneca, the same time, it's tab 9, again back to the judgment of Lord Justice Christopher Clark on page 176 of your authorities bundle, my lord.
Yeah.
He cites again from his own previous judgment in Omega Proteins at 23. It's paragraph 49 of Omega Proteins. The insured must establish that it has suffered loss, which is covered by one of the perils insured against.
Yeah.
That may be done by showing a judgment or an arbitration award against the insured or an agreement to pay.
Yeah.
Loss must be a scope as a matter of practicality, etc. So the burden is on the insured. And if that wasn't obvious from Omega, at the end of the passage in Omega, over the page on 177, as is apparent from that summary, the insured must establish both a loss and a liability. So the new point taken today is, in my submission, incorrect. The burden isn't on us, the burden is on the insured, because that's exactly where the burden would be had a policy been in place.
Okay.
So those are the three answers to that. May I just identify the issue in relation to O&R, and may I take this very quickly, which is, could I ask you please to turn in the bundle to page 47, which is the final page of O&R. Just above the final paragraph, the penultimate paragraph.
Yeah.
In O&R, as my lord, the Master of Rolls may remember, the route number 1 of Fraser and Furman
It was 26 years ago.
So probably not then. Route number 1 of Fraser and Furman wasn't an issue. It was just route number 2. What's the position on the collective contingencies? The quibble which Mr. Justice Butcher had with O&R, and the quibble that was had with O&R below, hasn't been taken here, is that in the final, when it says this question covers all the uncertainties which I've discussed, uncertainties whether if there had been no breach of duty, the plaintiffs would have got insurance and on what terms. That, we say, is properly an uncertainty. If they had uncertainties whether their claim would have been compromised or fought to a finish, if compromised, for how much, that's an uncertainty. The issue that arose below and before Mr. Justice Butcher was that the words "if fought to a finish, with what result" was being relied on to contradict route 1 of Fraser and Furman.
Yeah, well, I think the point that may be made against this case is that potentially one of the contingencies was something that was a matter of law or construction, or could have been proved or was proved, and therefore it should have, I think that was what was thought, that he was lumping everything together in route 2 and not considering whether there was an answer under route 1.
Well, or that may have been appropriate given the circumstances of the case.
It may have been, yes.
And in my submission it was, but
Okay.
the reason why Mr. Justice Butcher was cautious of it was the use it was being made of. So if fought to a finish, with what result, was being said to be a direction that always in a broker's negligence case you decide everything, every matter of causation on a loss of a chance basis. So you don't have route 1 in Fraser and Furman. So that's where the issue is.
Yeah.
May I just ask your lordships to turn, please, behind tab 12 in Perry and Rallis to paragraph 26 of Lord Briggs' judgment on page 266.
Oh, 26.
266.
Oh,
paragraph
266. Yeah. Yeah.
And it's that the same principle here would apply here. One doesn't have a value in a mere nuisance claim, in a claim for loss litigation. There isn't a value in a mere assertion that, well, insurers might have paid. Otherwise, there's no test for causation in a broker's negligence case. As soon as you've established a breach,
Yeah.
well, you've got an insurer to pay. And it's neither apposite nor fair that brokers should be deprived completely of a causation defence, which would be the effect of according weight to the principle that, well, of course, any claim might result in a payment from insurers. There has to be meaningful, in my submission, reasons for an insurer to pay, just as there were in Fraser and Furlong. In relation to the 5 principles that Milan Friend put forward, there's no identification of where those principles came from. There's no reference in support of any of those principles.
Well, do you recognise them?
In
You
my
say that they're wrong in law.
well, like many principles, it depends how far. So, for example, if the client can establish breach, then as a matter of causation, it must establish that it lost the opportunity of having in place insurance cover. Agreed so far. With an insurer that would or might have provided an indemnity in respect of the third-party claim, that's a reference to routes 1 and route 2 in Fraser and Furman. I have no quarrel with it. Number 2, a claimant does not have to plead or prove that it has an actual liability to a third party, falling within the terms of the policy in order to recover damages. There I say I don't agree with that, because A, it's not right for Fraser and Furman route 1, and B, there must be some basis in route 2 for the insurer to pay.
Well, you obviously don't agree it, or you wouldn't be arguing your round 1.
Yes. 3, whether or not a policy would or might have responded will be relevant to the loss of chance analysis, but without supplanting it. I agree up to the but without supplanting it point. It's obviously relevant to the analysis. I say that the position one gets to from Fraser and Furman is that it is the essential starting point for the analysis, because as part of deciding what their commercial decision might be, the insurer will consider the strength of their position and any legal advice they get as to whether there is in fact an entitlement under the policy. So in my submission, it is properly the starting point. Number 4, the court may make findings about whether the policy would or might have responded in considering whether the claimant has made out that it lost the opportunity of securing an indemnity. I'm not sure there's anything to quibble in that particular statement. But and I would agree, the court has to look, is there an entitlement under the policy, route 1? Is there an entitlement under the policy, the starting point of route 2? Is there a real loss of a chance?
Yeah.
The final point is just in relation to ground 5. So it's fundamental we keep being told we are only on the end of a claim, which is the orthodox claim. In fact, I believe it was the first sentence of Malone and Friends' skeleton, an orthodox claim by the claimant for the claimant not being insured against the accident. That doesn't include IMP, which is why IMP had dropped out the argument between first instance and now. And fundamentally, it doesn't include the reflective loss point, because Malone and Friend expressly disclaimed that he was trying to claim any reflective loss. It's certainly true that the relevant authorities are not in the bundle, and that's because he disclaimed any such claim. And so the only question then on the loss point for the court is this in fact a loss in value of the shares of the subsidiary? And if so, he's disclaimed claiming it.
Yeah.
My Lord, I'm very grateful for the Lord's patience. Unless there's any...
Well, thank you. Thank you. Do you want to come back on any of the authorities that weren't mentioned before? I don't know you have the right, but I'm sort of asking.
Well, my Lord, that's very generous. I mean, the point which my Lords will have was that the authorities on burden of proof are all claims against insurers, not claims against brokers, and I've given you reference to the claim against brokers.
Good. Okay, well, we'll take time to consider our judgments in this, what turns out to be an interesting matter. And when we do, we'll hand down a judgment in draft, no doubt, or judgments in draft, and it will be up to you to use them only to agree order and costs, not for any other purpose. And if you can't agree in order, we will decide in writing. But thank you to both you and your juniors and your solicitors for what has turned out to be a very interesting argument.
All right.